Hello friends, very warm welcome to my Business Laws YouTube channel. Today friends, I'm going to talk about nominee. 15 facts which you should know relating to nominee for bank accounts, FDRs, mutual funds and financial assets. So friends, you all know when we make an investment, we invest our money in FDR or we take an insurance policy or we take mutual funds or any financial assets. Then or we invest our money in shares. We are asked to furnish details regarding nominee. Now, various points I'm going to take up today regarding nominee. The various points of discussion: who is the nominee and why is nomination important? Which are the various rules regarding nomination? What is the role of nominee? What is the difference between nominee and legal heir? Is nominee and legal heir they are the same or different? There is difference. Or if you want to change your nomination, okay, then minor as a nominee. Can minor be appointed as a nominee or not? Can we appoint multiple nominees, that is more than one nominee? And what are the rules regarding nominee for demat account? What is the claim process? When the investor dies, then how can this money be claimed? And 3 cases of nomination I'll take up. Then who gets the money if nominee also dies? The investor has died. After that, unfortunately, nominee has also expired. Then who is entitled to get this money after the death of nominee? Many more headings, that is, if no nominee or legal heir is appointed. Then the second last is, can nominee be challenged by the legal heirs? And the last is, beneficiary versus nominee. What is the difference between beneficiary and nominee? So starting from the very first point, friends, I'll take up all these points one by one. Who is nominee, friends? A person to whom one can transfer the custodianship of his or her assets in case of asset holder death is known as a nominee. Note, friends, a nomination does not necessarily mean that you transfer your investments ownership as the full and final settlement to your nominee. You have given the name of nominee, doesn't mean, friends, after you die, then the entire money will be transferred to the nominee's account. So a nominee could be a legal beneficiary, or he or she could also be any other person who takes the permissible custody of the investor's assets in case of the investor's death. The nominee can be anyone you deem to be your first relative, your parents, spouse, kids, siblings, etc., etc. And now the question arises, why is nomination important? It is necessary, friends, for any responsible person to have a nomination in place in all of his financial investments. Whatever investment he is going to make, whether it is FDR or it is, mutual funds, or he has taken certain policy, okay, every time, friends, he has to furnish the details regarding nominee. In the recent times, in accordance with the revised guidelines, it has become mandatory or compulsory to put one's nomination before commencing any investment. So let us know now, friends, what are the rules of nomination. Nomination can be done in favor of one person. You should know, friends, it can be done in favor of one person only. However, nomination in favor of more than one person, that is up to 2 persons, not more than that, is permissible in jointly operated locker accounts with the mutual consent. Then what is the role of nominee? 3 points I would like to discuss in this context. First one is he has no right over your money, over your investments, unless specified under the will. If he inherits or if he inherits the money. Nominee is a mere custodian of the fixed deposits or investments. As per the Supreme Court judgments, a nominee is merely a custodian of the assets or money. The actual legal heir to the FD is the person to whom you left in your will. So friends, remember, it is will which is more important. So if the two persons are different, that is the person who has been mentioned in the will and the nominee, both are different, then the actual heir will have to claim the money from the nominee. Even if you have written somebody's name as a nominee, even then nominee is not entitled to get the money. He is merely the custodian of your investment. Ultimately, he will have to pass that money to the legal heir who has been named in the will. Moving ahead, friends, the next one is he is the contact person for the account. He is a person to whom the institution or the bank has to contact in case of the death of the investor. So friends, he is the contact person for the account in case the account holder is not reachable or is an event of the account holder death. Then what is the difference between nominee and legal heir? The nominee and legal heirs of the deceased, they are not the same. The nominees receive the investment proceeds and the assets upon the death of the investors. However, FD nominee is the only trustee and he has the right for holding the asset on behalf of the legal heir. Earlier also, friends, I have mentioned in my video that as per Supreme Court judgment, nominee is merely the custodian of the assets. He is the trustee of the assets on behalf of the legal heir. On the other hand, the legal heir is entitled to get the assets of the deceased as per the succession laws. It is the succession laws which is applicable. Then change of nomination. Sometimes, friends, what happens? We have to change the nomination. Say, girl has given the nomination. She's working, and to her employer, she has given the name of her brother, and then she gets married, and now she wants to, change the nominee. She wants to make a husband as a nominee or son as the nominee after her marriage. Then one can always change, the name of the nominee anytime during the term of the investment. There is no restriction on the number of times. N number of times a nomination can be changed. There is no restriction at all. It is better for you to review the nomination periodically. Initially, you could have kept your mother as a nominee. After your marriage, you may change it to your wife. Later, when your children become major, you may change the nominee as your son or daughter. So, I mean to say, friends, nomination must be reviewed on periodical basis, on constant basis. So remember, friends, you can always change your nominee an n number of times. There is no limit, there is no restriction on the number of times. Moving ahead, friends, now the question arises, can minor be appointed as a nominee? Even you can appoint minor as a nominee. In case a nominee is a minor, an appointee looks after the asset. Because he is a minor, then appointee will look after the asset until the minor turns into a major. The minor attains the age of 18 years. He becomes major. So in addition to selecting the nominee, you need to select the appointee for the minor nominee. Remember, friends, you can always appoint minor as a nominee. But apart from minor, you will also have to appoint appointee. Moving ahead, friends, next one is multiple nominees. Life insurance has also the option of having more than one nomination. In my earlier discussion, I've told you only one nominee can be appointed, but rules are different in case of life insurance. In case of life insurance, you have to appoint multiple nominees, which divide the investors assured sum among all his nominees. So whatever is the number of nominees, the insured sum is divided among all. The next one is nominee for demat account. The nomination in a demat account will not be like that of life insurance or mutual funds. So we are having different rules here, altogether different rules here. The nominee here will be the legal beneficiary of the shares. Therefore, one must take care while selecting a nominee for this account. So remember, friends, in case of demat, the rules are different. Whosoever is a nominee, he will be the, de facto beneficiary of the shares. According to the Companies Act, this account's nominee, demat's nominee, has the power to supersede the will. Otherwise, the will supersedes the nominee in other cases. But in this case, the nominee will supersede the will, thereby transferring the shareholdings to the nominee's demat. Now, moving ahead, friends, the next one is claim process. What is a claim process? What are the various steps involved in the claim process? So, the investor assets, they are not transferred automatically. There is certain stipulated, specified claim process which has to be completed, which has to be followed. Now, the question arises, what are the various steps involved? I'll discuss all these steps now. First one is the nominee must first inform the respective financial institution, maybe a bank or LIC or any investor company or any other institution, depending upon the investment, that so and so investor has unfortunately left this world. Thereafter, he must seek knowledge of the assets claiming process. He must find out how many assets are there regarding which he has to get the claim. Okay, and the last one is there. The nominee should also submit the mandatory documents to validate his asset transfer as stated under the law. And now, friends, there are a number of institutions who have put restrictions here. So it depends upon various regulatory bodies. The steps which he has to follow, they're different. They're different for for every investment. But there are some of the primary documents which are common to all, which are required by all financial institutions, whether it is a bank or LIC or any other financial institution. So let us know which are these now. The first one is identity proof of the nominee. Then KYC compliance in case of mutual funds and demat accounts. Then probate of will, which he will have to get from the court. Succession certificate, the claim form, and the death certificate of the unit holder or the asset holder. And now, friends, I'll take up 3 cases of nomination. The very first case is before you, which is when a person has written a will before his death. You have written a will, but the person you have nominated to receive money from your fixed deposit in bank, say let us talk about Punjab National Bank, is different from the person to whom you have distributed the same FD in your will. Both are different. Nominee and the person which you have written in your will is different. In most cases, after your demise, after your death, the bank will transfer the FD money to the nominee. You mentioned in the FD form, where the FD is held only in your name, it is not jointly held. Okay, so there is no joint account, it is in single name only. Then the amount will be transferred to the nominee account. Now, coming to the second case, when a person dies intestate, that is, no will has been left by him, then your assets will be distributed among your legal heirs as determined by the succession laws of the country as applicable to you. Succession laws vary depending upon the religion of the person who has passed away. It depends to which religion he belongs. Was he a Sikh or Hindu or Christian? It depends. So normally the laws classify family members as class 1, 2, and 3 heirs. And the wealth of the deceased is distributed by the court among all these. If there are no class 1 heirs, then the property goes to class 2 heirs. And if no class 1 and 2 heirs are there, then the property will go to the agnates. What is the meaning of the term agnates? Agnates are a distant blood relative of the male lineage. If no agnates are available, then it goes to cognates. What is the meaning of cognates? Cognates are distant blood relatives of male or female lineage. And if there are no cognates, then of course, friends, the money will go to the government. The money will be kept by the government. Now, the question arises, who qualify class 1 heirs? All these will classify, they have been put under the category of class 1 heirs, son or daughter, widow, mother, son or daughter of a predeceased son, and all these. And now coming to class 2 heirs, they include father, then sons, daughters, son, like this. So these are the various categories which will qualify class 2 heirs. Now, friends, I would like to discuss here, as per Hindu succession law, every legal heir of the same class, that is, say class 1 or class 2, they have the equal right on every asset of the deceased if there is no will. That is, we are talking about intestate state. The bank will normally pay the money to the nominee and he or she will be required to transfer it to the legal heirs as per their entitlement. Now let us talk about the case 3. Case 3 is the special case. In case 3, friends, nominee will be entitled to get them in special cases. That is why the term has been used here special. In case of certain assets such as Employees Provident Fund, EPF, Employees Pension Scheme, which is EPS, and the gratuity, only defined family members can be nominated by the person. A person cannot entrust money from EPF, EPS, and gratuity to anyone other than those defined family members in the will. So there are certain members who have been defined as family members. Only those members can be nominated by the asset holder. But in case of violation of this rule, if those defined members have not been nominated, then the nomination takes precedence over the will. Meaning thereby, the beneficiary under the will would not get the money and the nominee will be entitled to keep the money with him or herself. If the nominee supersedes. Okay, so moving ahead, friends, now the next point which I would like to discuss is who gets the money if nominee also dies. If a beneficiary nominee or one of your beneficiary nominees, they die after your demise, but before his share of the amount under the policy is paid, the share of such nominee or nominees shall be payable to the heirs or legal representative of such nominee or holder of succession certificate of such nominees. So in case nominee dies after your death, then the money will go to their legal heirs. They will be entitled to get the money. Moving ahead, friends, if no nominee or legal heir is appointed, Sometimes it may also happen. Then in that case, if individual has not appointed the nominee, then the bank or the institution will try to trace out the legal hire of the investor. If they fail to trace the legal hire, if they have tried their best and the legal hires are not traceable, then the bank will keep the money in a separate account and they will wait for someone to claim it. But whoever wants to claim it will have to produce the proper proof. Can nominees be challenged by the legal hire? As per Supreme Court judgment, a nominee is merely a custodian of the assets or money. Not a new point, friends. Already I have discussed. And the actual hire to the FD is the person whom you left in your will. That is more important. If the two persons are different, then the actual hire will have to claim the money from the nominee. So, friends, the money is not transferred to the nominee account. Nominee is the trustee, he is the custodian. He will get the money and then he will have to hand over that money to the legal hire who has been named in the will. And the last point which I want to discuss is beneficiary and nominee the same person? Are these two the same? No, friends. These two are not the same. A nominee is a person who holds the property of the deceased until he has to distribute his property to the legal heirs. He's a custodian. He's a trustee. Ultimately, he will have to hand over this to the legal heirs. In a life insurance policy, the beneficiary is an individual who you have to nominate to receive the policy proceeds after an unfortunate incident takes place. So beneficiary will be entitled to get the money in case of life insurance policy. So this is all about today's lecture. Friends, I've covered 15 facts regarding nominee pertaining to various investments, let it be FDR or mutual funds or life insurance policy, etc., etc. So friends, I hope the content will be useful for you. And if you have any doubt, you can write comment in the comment section. You can put your query in the comment section. Friends, do subscribe to my channel if you have not subscribed yet. Do press on the bell icon to get notification of my subsequent videos. Keep smiling and be blessed always. We will meet soon. Goodbye, friends. Goodbye.